What's up, everyone? This is Nick Carter with another episode of On the Brink. This week we have a fascinating guest. So if you follow litigation in crypto, you will definitely have heard of him. I'm speaking, of course, of Brian Klein. Brian is a trial attorney with Baker Marquart, and he has participated in some of the highest profile court cases in the crypto industry to date. So Baker Marquart is a nationally recognized litigation boutique, and they're actually in the process of rebranding. They're moving away from the traditional use of the names to the more modern approach of a trade name like Google or Amazon, reflecting their forward-looking client base. So stay tuned for an announcement on that front. So Brian has been involved in a string of recent successes in litigation. He was part of the team that negotiated the class action settlement on behalf of the Brightmans relating to Tezos. He also represented Block 1 in their settlement with the SEC last year. And both of those cases are perceived as ending in a very favorable manner for Brian's clients. Brian has also represented individuals like Charlie Shrem and Erik Voorhees. He's been active in the crypto industry for a long time. So I wanted to get him on the show to discuss how and why he first started taking cases in the crypto industry and how he rose to prominence, and to get his views on controversial topics like token issuances, the SEC's role in this industry, and of course, the controversial SAFT model, which is currently being interrogated in the Telegram case. We also talk about some of his high-profile pro bono work, like his representation of Marcus Hutchins, also known as Malware Tech. I personally hope I never have the need for high-powered legal counsel, but if I do, I know who I'm calling. Let's jump right into it.
Brought down by bad mortgage investments, Lehman, which has 25,000 employees, will be liquidated.
The federal government loans American International Group, AIG, $85 billion.
This is a different kind of market, and the Fed is asleep.
The federal government is stepping in to stabilize Fannie Mae and Freddie Mac, the two mortgage giants that have been threatened by the housing crisis.
The Bank of England has pumped £75 billion more into Britain's ailing economy with a new round of quantitative easing.
You print a couple $1 trillion, and all of a sudden, people start to worry. So out of this worry, we have something called the Bitcoin. Bitcoin.
So Brian, welcome to the show.
Great to be here. Thanks for inviting me.
I think it's no exaggeration when I say that you are probably the most impactful litigator in the crypto industry right now.
I very much appreciate that. There's obviously a lot of litigators in the space, and I've been working really hard to do what I can for my clients.
Yeah, you've had a string of kind of high-profile cases, settlements mostly, which I'd say resolved, in favor of your clients, and almost at the point where you're a household name. I'm curious how you came to be so deeply involved in the crypto industry. How did you get your start?
So I first really focused and heard about Bitcoin back in early 2013. I remember I was a federal prosecutor for 5 years in Los Angeles. I had recently left the office to go back into private practice and focus on criminal and regulatory defense at a boutique firm in Los Angeles. And I had read about FinCEN, which is an arm of the Department of Treasury, issuing some guidance on virtual currencies. And that piqued my interest immediately. In the back of my mind, I had heard about Bitcoin, but I hadn't spent any time thinking about it or focus on it. And then I went down the rabbit hole that many people go down when they first learn about Bitcoin. Now, at that point, it was a very different world in early 2013. I remember setting up like a Google alert for Bitcoin, and maybe you'd get like one story a day, but it felt like one a week.
Wow.
And there weren't any real lawyers in the space that I could tell. There weren't cases on it. There weren't like litigations happening or prosecutions or it was a very, very small industry at that point, but I was totally enthralled. I had grown up in the Bay Area in Seattle and always been around technology, always had liked technology, was always interested in it. And so then I wrote this short article for a legal journal out in California about Bitcoin and the significance of that ruling, which actually, looking back, I've looked back at it recently, it actually holds up pretty well. And then I typed in Google, I was like, Bitcoin conference, and literally one popped up. And it was this San Jose conference put on by the Bitcoin Foundation. I think that was in May 2013. And I signed up for it, and I saw the spreadsheet of speakers, and I got put on a panel. talking about regulatory compliance, I believe, and sort of the space, but was really focused on the FinCEN guidance. That was really big news back at the time. You know, the space was a buzz. Now, I didn't really know that until I went to San Jose. I remember that conference very well. I remember going up there, not knowing who any of the players were, not knowing how big the industry was, even other than knowing it was pretty small. And I went to the speakers dinner the first night. It's the first thing I did in this industry at all. Walked upstairs to this Mexican restaurant, and the first person who introduced himself happened to be Brian Armstrong of Coinbase, which I think at the time was 3 employees. And he's a very gracious, nice person. And then I, was at that conference. And that really was a deep dive into the early parts of the industry. It was sponsored by SatoshiDice, the Winklevoss twins gave a keynote speech. I remember very clearly that next door was some sort of anime conference, and it was sort of hard to tell the difference between the two because people were in masks, wearing masks in both. I met a bunch of other early industry people. Ripple had a small table. I mean, these were like little fold-out tables in this giant warehouse, sort of cavern at the San Jose Convention Center, and Ripple had a table. Coinbase had a table. I remember meeting Patrick Merck, who was at the time at the Bitcoin Foundation.
Yeah.
He's a lawyer. He's well known in the industry, and that he was the first person who got me involved substantively in like doing legal work. I volunteered to help the foundation and ended up heading up the committee on legal advocacy, and really started going from there and started to meet a lot of people in the industry and get more involved.
Do you remember what you said on the panel about FinCEN, about money transmission?
I remember the general conversation. I'm sure there's a video of this. The tone was, this is real serious guidance, and this means that law enforcement and regulators are paying attention. There is sort of a halo effect because and it sort of intrigued me when I saw, because I'm like, oh, the government's taking this seriously. That means this must be something that is growing and is something that's it's getting on people's radar, not just in the tech circles, but even in government circles. They're taking it very seriously. To issue guidance is a process. And I remember the general advice was sort of, you have to take this seriously and you have to comply with the law. And I remember some people asking questions like, well, it's Bitcoin. Do I still need to follow? I mean, this wasn't exactly the question, but sort of the tone was like, well, we really have to follow the law, kind of was some of the questions from some people. And it's like, no, yes, you really do have to follow the law. Otherwise you will get in real trouble. And I was the defense lawyer, criminal defense lawyer on the panel, and the former federal prosecutor. And, could of course speak to that now that there were these laws that the FinCEN intended to apply to this, that there would be prosecutions. That's the next step. They're putting this guidance out so they can start to bring enforcement actions, whether civil or criminal. And that's exactly what happened over the next, since then.
And at the time, I mean, I think Bitcoin might have been kind of around about $1 billion in its total market cap. Was it surprising to you that FinCEN was spending real energy on this, tiny kind of minuscule upstart currency?
It was, and it wasn't to me. It was in the sense that you're right. It was very small. I remember I bought my first Bitcoin, and I think I bought it for around $80, $90. I bought it through Coinbase. And I think they saw some of the potential. They also didn't fully understand it. And there was a lot of confusion for a lot of people, both in the mainstream media, mainstream business, about the pseudonymity of it, right? And how it could be used and how it might be able to be misused, the way the government would look at it. Now, the other thing was, I think there were people at FinCEN who, like me, had read the white paper, read about it, and were enthralled and very interested, and felt like, in terms of like regulating money, there hadn't been a lot of developments for a long time, right? Now all of a sudden you have this explosion of a new type of money, sort of unprecedented. And so I think that's what made it really interesting. I think during that time period, that first year or two, a lot of banks were interested in. I remember getting invited to go to a bank and talk about Bitcoin. They weren't going to bank Bitcoin or even let people do it, but they were fascinated by it. This idea that there was this currency out there that wasn't issued by a government and that people were using to purchase things. I think a lot of people saw the real potential.
What was the first case that you took in the crypto industry?
I think my first case was representing Erik Voorhees in connection with his SEC settlement. I think the settlement was announced in 2014. It related to SatoshiDice and the issuance of unregistered securities on a Romanian exchange. So everything about it was very novel for, I would say, everybody, both the SEC and for me. It was the first unregistered security settlement in the space. Erik is a genuinely amazing person, a real visionary, and just a really kind, caring person. So it was a real pleasure and honor to help him through that process. And I think it was widely viewed as a very favorable resolution for Erik.
Was that exchange the one that Marcia Popescu set up?
I believe that's right. I don't remember the name precisely, but I know it was Romanian, and that name sounds Romanian to me. So I think you're right.
I think it was. That's so crazy. I wonder what happened to that exchange. So Erik effectively sold a financial product relating to the usage of SatoshiDice. Is that kind of the crux of the matter?
Yeah, the settlement covered the sale of shares of SatoshiDice through that exchange. And if you read the settlement paperwork from the SEC, you'll see that, as I remember it, I haven't looked at it recently, but everyone received a refund, actually, or sort of had their shares purchased back. That's another way to put it. And then SatoshiDice was subsequently sold.
Yeah, he sold it. Yeah. If you look at the usage on chain, SatoshiDice was like a preposterous fraction of the usage of Bitcoin block space in from, I guess, 2011, 2012 kind of time frame.
Yeah, I think it was like 60% potentially of in certain time periods of all use of the blockchain. But I think, it showed, one, that people could trust it because it was the way SatoshiDice was set up, as I remember, was the sort of provable, verifiable roll of the dice, and you got rewarded if you hit, basically based on how the blockchain came out.
Yeah, I think it relied on vanity addresses, if I'm not mistaken. So you would send a Bitcoin payment to an address which had the odds encoded in the address name.
That sounds right to me.
I always thought that was very clever. Yeah, vanity addresses kind of went out of style, I guess, because they're not good for privacy, obviously. For one Christmas, I made vanity addresses for my family, so because you can kind of mine them, right? It's the same process as mining, except you can't make a whole one because you'd be able to crack effectively an address. So it's thermodynamically difficult to do a whole one.
I can tell you, I know when the power of Bitcoin first hit me, which is somewhat related, which was I joined the Bitcoin Foundation. At that time, you had to donate. I think it might have even been a Bitcoin. Maybe it was a quarter at that point. I forget where the price was.
Wow.
And so I bought my first Bitcoin to join the Bitcoin Foundation. And I remember sending it to the foundation's address. And then I was like, well, how do I know it got there? So I actually called them, which this sounds so silly in hindsight. I literally called and spoke to a woman there and said, hey, I sent my donation in. Did you receive it? And she's like, yeah, you can just check the blockchain. I'm like, oh, duh, right? It hit me. I was like, duh, that's the whole point.
It's the whole point. Yeah.
Yeah, but it was funny because it didn't occur to me because my mindset was so used to the way the fiat system works, right? Which is you write a check and you see it cashed, or you do a credit card and you check your receipt or your balance of your credit card or your online. And sort of that like silly moment in hindsight, really naive moment, really like imprinted on me like the power of Bitcoin, which is I didn't have to trust that she was even telling me the truth, right? I could just check and know.
So in your trajectory throughout this industry, did you take cases because you were interested in the subject matter, or was it just you went from one to the next and people referred you and you gained a reputation within crypto Was it kind of due to some ideological motive, a desire to work on crypto, or was it just kind of a sequence of referrals?
I think it's a lot of both of that, or it's a mix of all of that, maybe is a better way of putting that. I am by nature, have a lot of libertarian impulses. So there's a lot of attractive things to me about Bitcoin based on it not being attached to a state. And then I think it's also, I'm always interested in technology. So, Bitcoin kind of really combines a lot of those things together. I think a lot of the early adopters were libertarians or people very interested in technology. And I also think, I was fortunate that these cases are all interesting, right? You were sort of charting a new path on each of these cases.
Yeah.
And to me, that was really exciting. It wasn't like I was defending the 4,000th person accused of running a Ponzi scheme, right? It was the first person ever to have an SEC settlement, basically, or the first person to be charged under this statute, or one of the first people, right? And there wasn't a lot of case law or decisions by judges about these issues. So there was a lot of very interesting legal arguments you can raise that would be heard for the first time. That's still true to this day. There's a broad swaths of legal decisions that haven't been made. There's a lot of open territory still.
Yeah.
Which makes it really exciting.
Yeah, I was going to say there's new ground being broken, especially on the securities laws front, but I'm sure also in the context of the Bank Secrecy Act and AML and so on. But yeah, I mean, that's kind of a nice segue to get to securities laws in the context of crypto. So you're obviously known for having negotiated Block 1 settlement with the SEC. And it seems like one critique of the SEC is that it's very unclear where token issuers stand, whether effectively what happened to Ethereum can be replicated, whether there's a path to decentralization that's possible, even if you have an issuance that looks like an investment contract. What do you make of the SEC's kind of evolving stance on this? Do you think that they've provided industry with sufficient information in terms of the Howey test as it applies to tokens?
I don't think they have. I think there's a lot of, in my mind, they could be doing a lot more. And I remember a couple anecdotes to get to that point, which is I remember there was I think it was the first consensus. So it must have been right before the ICO boom. No, maybe not the first consensus in New York. It was a consensus in New York. This was 2017.
Uh-huh.
And I think the DAO was happening at that time.
Right.
Or it started to happen. And a lot of people were wondering, like, where is the SEC, or what are the rules on this? And I was at consensus in New York, and I ran into an SEC official I know really well from other cases. And I said, what are you guys going to do anything about this? Are you going to put out any guidance? There's, a lot of my clients are trying to understand what the rules might be and want to comply, but they're having a hard time figuring out how the SEC might view this, and that would be very helpful for them to know. And then they ended up issuing the DAO report. I had a client I represented in connection with that. And the DAO report, in the SEC's mind, I think was like, well, here's how you should understand Howey. The problem was the DAO is very different from the token offerings that happened.
Yeah.
Right. The DAO was essentially a virtual venture capital fund.
That's right.
What I could tell. And the token offerings were incredibly different. They were people raising money either not for a percent of equity or even for a percent of profits, but raising, funds through the receipt of Bitcoin or Ethereum most often, and then providing people with access to tokens down the road and building out projects or blockchains. And I think that guidance really didn't answer. And then there were a bunch of decisions or actions they brought after that, including Munchie, which is a well-known one. And for the most part, they were going after things that were that the SEC thought were either very blatant violations or fraudulent in nature. But even those, it wasn't clear. And I think there was a lot of mixed messaging. I think there was a lot of people at the SEC who understand the technology, don't want to trample on it. But I think it's a big bureaucracy, and there's a lot of sort of things in the way of probably getting clear, concise guidance out, like the kind that Hester Pierce, who's one of the commissioners, seems to be strongly advocating for, both externally and internally. I have good relationships at the SEC. I deal with them a lot. I think there's a lot of hardworking, honest, decent people there who, in their mind think they're doing the right thing and think that they're properly enforcing securities laws. And often we have disagreements about that. But I think the SEC could doing a lot more. And frankly, I think I would have preferred that they did less, right? You could say, oh, they could be doing more in terms of getting guidance, but I would prefer they did less in terms of enforcement action, that they had sort of let the space figure it out a little bit and only jumped in where there was real fraud rather than jumping in when it's an unregistered offering, or in their mind, an unregistered offering. So I might have, if I were in charge of the world, I would have had a much lighter touch on these things and focus on the really cases that are real obvious abuse.
What did you make of the Hinman speech, where he was pretty explicit about outlining how something could begin life as a security and then transmute potentially to a commodity? I know in the legal analysis, apparently those are actually overlapping categories, and then the question is whether there's an investment contract pertaining to a commodity. But the point is, I think there was an attempt there to outline how something could be understood as sufficiently decentralized, and thereby avoiding, some of the prongs of Howey, maybe the efforts of third party prong. Did you find that was helpful? Kind of informal guidance, or because I know a lot of tokens started to try and kind of design against that, but then it seems like maybe that's been jettisoned now.
I think the intentions were good there, and I think he did offer some insights. The problem is Howey doesn't talk about decentralization, right? That's a concept. I'm not saying it's invented, but it's a concept that was out there before, and it was a speech he gave in Silicon Valley that they did publish, and it provided some guideposts, but it wasn't definitive, right? And it was just guidance. And, the factors were so many, and then there's been subsequent follow-on guidance, the framework they issued later, I think a year later. There's just so many factors. And of course you could find ways that your token does or doesn't comply with some, but not all of them. Again, I think it's just the intention, I think, was probably the right intention. But the reality is it didn't really give anybody any comfort, right? You need clear guideposts, and they just weren't there. And I think most of the guideposts they've offered have been through their enforcement actions, which are, sometimes like reading tea leaves.
Yeah. I mean, do you think that with enough cases maybe resembling Block 1 or Telegram, we'll eventually get sufficient case law for there to be a set of precedents which are ironed out and a set of effective rules?
I think we will. I mean, I think the one thing the SEC's actions did do was it really shut down the quote ICO market, right? The number of ICOs, also the collapse in the price probably shut it down too, but I think those kind of might have gone hand in hand a little bit. So I think we will get to a place where courts will be providing more insights into things. I think that takes a long time for things to work through the court system though. If you look at, for example, the Telegram case now, that case, the SEC brought a complaint sort of late last fall. The judge just issued a order on a preliminary injunction, which I understand Telegram is now appealing. If that gets appealed, it goes up to the Second Circuit, and that could take, maybe 6-9 months. That'd probably be fast, actually, especially in light of what's happening now with the pandemic. So you're talking still years from the courts really starting to give some clear signals about what's appropriate. And then again, that case is in the Southern District of New York, which is in New York. So that judge's ruling is not binding precedent on a judge, for example, in California. It's not even binding on a judge in the same courtroom there. It's persuasive and it's supposed to be valued, but it's not binding. You have to wait for an appeals court to issue a decision for it to be binding, and that hasn't happened yet. So I think waiting for the courts, I think, is waiting too long.
This might be a silly question, but what are the odds that one of these cases ends up in front of the Supreme Court in the next couple of years?
I think that's a real possibility. I think the issues are important and novel. Usually you want a circuit split, though. The Supreme Court is looking for two circuits saying different things. That's not always the case, of course, but that is often something that causes the Supreme Court to decide to review a case, an appeal. But I think, the Howey test, and, it wouldn't shock me if Telegram or even Kick, which is happening in the Southern District too, ultimately went up to the Supreme Court. I'm sure either side who lost would appeal as far as they could, whether it's the government or the private parties in that. So I think that's a real possibility.
Speaking of the Telegram case, so I am a layperson, but I found that I very much agreed with the judge's reasoning in granting that injunction. Who, effectively the logic was, well, there was the sale, the SAFT, to 100 or so, investment vehicles, venture and hedge funds and so on. And the judge was effectively saying that those weren't just the end buyers. They were actually implicitly planning on redistributing the grams on the open market. So they're actually effectively acting in the capacity as an underwriter, which has sort of always been my view on this, that the SAFT and then this like public release that happens in an informal way on the secondary markets, that's sort of the objective of the issuers all along. I mean, did that seem persuasive to you?
No. I disagree with his opinion. I disagree with the analysis. I disagree. I don't disagree that, the SEC did win that day. Of course, they did. They got what they wanted, for now at least. But I wasn't persuaded by the judge's reasoning or his presentation.
Really?
And I think that, the SAFT framework, like any framework, depends on how you execute it. So, and I'm not saying Telegram did something improper here. I'm just saying in general. So like any framework, you could follow it or not. And so I don't think this was the death knell of the SAFT by any means. Nor do I think it means that Telegram's ultimately going to lose. I think there's a lot of issues there that are ripe for an appellate court to review and change that decision on. And if I were representing Telegram, I would be strongly advocating for an appeal. I would be, I think there's a lot of issues they can raise on appeal, just about how the judge chose to look at things. I think it was very clear how the judge felt. The judge wasn't persuaded by Telegram's arguments. For example, if you look at the opinion, I don't have it in front of me, but I remember that the judge very specifically cited to investors that the SEC had interviewed who said that this was really, in their mind, like an investment, like a stock or a securities offering. Not quite like that, but that's the gist of it. But I know from just looking at the docket that, and reading the filings, that Telegram had submitted a number of declarations from people who had engaged in the sale and were saying something different. And those weren't cited and given as much authority. I also thought it was interesting that the opinion spent a lot of time talking about how, well, you have to look at it at the time of the sale, but then he also spent a lot of time talking about what was going to happen in the future. So there was a sort of a mixed message there.
Yeah.
To what you were getting at. He said, well, it only matters what happened at the time of the sale, but then let's see what they were going to do, 6 months, a year from now when they got the tokens. Well, then what matters is not what just happened to the sale.
Right.
So I think there's a lot of good legal arguments that Telegram can and will, I'm sure, marshal to defend itself. And I think they will get some traction, or should get some traction, on appeal. Now, I think, if I remember correctly, this appeal, the Second Circuit, it's by permission, so it's not an automatic appeal. I think the Second Circuit should be interested in this issue, and will hopefully hear this appeal.
So, given that the kind of vanilla ICO is out of favor and the SAFT is, in the middle of this controversy, do you feel that there is a plausible way to issue a token in 2020? What choice do issuers have today?
Absolutely. I think there are plausible ways to do that in 2020. I think there were plausible ways in 2019, 2018, 2017. I think there were legal ways. I think it's, my saying is I don't give opinions, I defend them. So I don't advise companies. If a company comes to me and says, "Hey, Brian, we plan to do a token sale, tell us how to do it," that's not the kind of advice I would give.
Right.
I would give advice on sort of like, well, here's how the SEC enforcement arm might view that, and here's the things they might care about. But you still need to consult with securities counsel, compliance counsel, in addition to me. I very much try to stay in my lane on that, because my strength, I'm a litigator, I'm not a compliance attorney. I go to court, I make arguments, I marshal the facts and the law to help my clients. I defend them when they're being investigated. But you don't call me and say, "How do you set up a AML program?" or "How do I make sure I do this, Form D filing correct?" Right? I don't give that advice.
One thing that I've noticed is that a lot of the kind of secondary participants or ancillary participants in these offerings that are engaged in some way in the industry that maybe, derive their revenue from the existence of these issuances, exchanges being the primary ones. And in many cases, exchanges were kind of direct underwriters when they had IEOs happen last year. They've been sort of spared scrutiny as far as I can tell, especially these offshore exchanges. Is that surprising to you? Have you expected the SEC or other securities agencies to kind of turn their eye to them?
Well, I think I'll answer that question sort of from a different angle, which is I think anytime you're offshore, it's a lot harder for any U.S. agency to engage with you, whether it's to issue a subpoena, to interview people, to try to get you into the fold, right? Because you're offshore. You may be in a jurisdiction that doesn't honor U.S. laws or reciprocally honor them. You may not choose to engage, right? So I think it's not that surprising that when you see enforcement actions in the U.S., whether it's from the SEC, the CFTC, or anybody, they're largely U.S.-based companies or individuals. That's not always true, of course. Kik is up in Canada. But for the most part, it's a lot easier for them to connect with those people or those companies. So I think that's one element you might be seeing at work there, which is, Bitcoin or the token world is a global community. The U.S. is frankly, I think the exchange activity in the U.S. is a relatively small percentage compared to the global exchange activity. Coinbase, Gemini, and Kraken and Bittrex, I think, are less than 25% of the global exchange activity. I could have that number wrong; it changes, but
yeah, it's hard to measure.
Most of the activity seems to be abroad, and I think Binance at one point has been the clear leader. I don't know where it is today. So I think that's part of it. I think the other thing is that a lot of these tokens aren't securities by any means, right? So, and I think, the SEC's job is to enforce the securities laws, not to enforce other laws. My understanding is the threshold question for them in every case, and it should be, does this implicate the securities laws? And so if it doesn't, they may not choose to look at it. I'm not saying they're not looking at all these tokens, or maybe haven't looking at some exchanges, but I think that's a real issue for everybody here. And I also know that the exchanges in the US, from what I know, have done a very good job of putting in place programs to vet tokens, do their own Howey analysis, come to great comfort that they're not. There's that group that has put out now this sliding scale of 1 to 5.
Yeah.
So I think the U.S. industry has been has been very responsible about how it's undertaken this process of vetting tokens before they get listed.
Yeah, this has always been kind of my interpretation, is that, from my lay point of view, securities laws are all about getting material information out to the end users or the end purchasers, and having good disclosure standards. That's one thing where I think the industry lags. I mean, I feel like there is no single repository for disclosure. There's nothing even resembling Edgar. There's no equivalent of annual filings. And a lot of token projects will say, well, it's all on chain. There's a lot of complexity involved in auditing that stuff. And in my opinion, a lot of the material stuff is not stuff that's strictly on chain.
Well, but if it's not a security, why do you need those disclosures? Those disclosures, I agree with you. The SEC's general purpose is to, if it's a security, to make sure that people who are purchasing that security or involved with it have the necessary information to make informed decisions, right? And to protect investors. But if they're not securities, then, they don't necessarily have to provide the same level of information. The other thing I would say is I know there are projects that are trying to do things like Edgar. I think Nassari, Ryan Selkitz's project is building a platform that's trying to provide, or is providing transparency on a lot of projects. Although I understand it's voluntary who participates in it. So it probably doesn't cover all the tokens.
I guess my point was, if there's some gradualism here between security and then something that looks like Bitcoin, which is entirely voluntary and, very decentralized, if there's some intermediate step, it seems like there should also be some intermediate standard of disclosure that exists if there are buyers for these things. And if the whole, spirit of securities laws is to help investors discover the important facts about these issuances.
Yeah, I mean, I'm not saying I disagree with you, but I think one thing you should keep in mind, or anyone should keep in mind, is it wasn't always clear that Bitcoin wasn't going to be considered a security. I mean, it seems obvious to us now, and I'm not saying I ever thought it was a security, but I have heard very definitively that at the SEC internally, they spent years thinking about it, and frankly, from what I know, trying to make it a security in terms of how can we fit this into the Howey test. Ultimately, they couldn't.
Really?
So I don't think, and I'm not saying that everybody at the SEC felt that way, but I think that there was definitely, from what I know, a real sense of that all the way up to the higher reaches. Now, that didn't happen, and it was, the CFTC said it's a commodity, and Vincent said it's money, and et cetera, but I think, regulators really need to stay in their lane. I think that's a really important thing for me philosophically, is that there's a concept of overreach, and regulators love to expand their grasp because it means they get to do more things. It means they get more budget. It means they grow in size and importance. And I think we need to try to keep a limit on these regulators as much as possible so that they stay in their lane and focus on their missions as much as possible.
This might be a bit of a controversial question, but if you had to grade the various regulatory agencies that engage with crypto in the US in terms of who has had the best light touch yet most prudent approach, which one would you give an A to?
Well, I think a light touch, like I said earlier, is the best touch. So, I don't want to grade them because I would resist that concept as a good one. But I will say this: I think, what you've seen is the CFTC has done fewer things. I mean, their mandate is somewhat smaller. They're a smaller agency. I think they've been very surgical for the most part. I think the Department of Justice, in their mind, has focused on what they view as criminal activity and haven't tried to sort of really overreach. Doesn't mean they haven't brought cases they shouldn't have. It doesn't mean I agree with any of all their decisions, but I think they have, at least in some areas, I'm aware of some of their informal guidelines on what kind of cases they bring. And I think they feel like they're trying to do the prudent thing. So I don't really want to give the agencies grades, nor do I think they care what grade I give them. I'm sure they don't. Sometimes, if I said they get an F, they might view that as an A too, right? So
didn't mean to put you on the spot. On another topic, so I think the number one case that Bitcoiners fixate on is the Silk Road case. Well, there are actually lots of cases relating to the Silk Road, but Ross Ulbricht specifically. So, unfortunately or fortunately, depending on your stance, he ended up with, seems like a double life sentence, I believe. Do you think that was a proportional sentence, and would there have been something you would have done differently if you had been representing him?
So I represented a client tied to the Silk Road, a guy named Gary Davis, who was extradited from Ireland and was sentenced. He was essentially an admin on the Silk Road. He pleaded guilty. So I'm somewhat limited in what I can comment on in that case because of my representative of Gary, who is a terrific client to help. But I will say this, I wouldn't give anybody a life sentence barring, a terrorist, right? Who's killed a lot of people. I think people should be given a chance to get out. They should have something that they can, when they go to prison, know that they're not going to die there, that they can work on bettering themselves or get through the process and get out. So I am opposed to almost every life sentence. And I think Judge Forrest, his judge was known as she's now left the bench, is back at her law firm, was known as a particularly tough sentencer. So I don't think that was the appropriate sentence. As to what I would have done differently, that's really tough to say because I didn't represent him. I don't know all the things that happened there. I don't know the decisions that Ross made. One thing I think people forget is, lawyers, obviously we can do our job and we control a lot of the case in a criminal case, particularly in terms of legal strategy and things to do. But there's a few decisions that are very much up to the client. And two of those are whether they testify at trial or not, and whether they take a plea offer or want to engage in plea discussions. And, it might have been the case where Ross did not want to entertain a plea. I think if he had pleaded guilty and not gone to trial, I think he would have not gotten that strict of a sentence. I think he probably would have gotten, I would guess, based on what she sentenced him to after going to trial, probably 20 to 30 years. But I think his going to trial really cost him. I don't think it should necessarily be that way, but I think that often is unfortunately the way it happens, that if a client goes to trial and loses, they're going to get a much longer sentence than if they had pleaded guilty before trial. So in that sense, it didn't surprise me that he got a draconian sentence. But I do think that was much too harsh of a sentence.
Do you think that these occasionally what appear to be disproportionate or very harsh sentences are kind of part of the social contract that we have with our criminal justice system, in terms of some of these cases are meant to be cathartic for society, and that's why we tolerate occasionally extreme sentences? Or is it just a function of the fact that some judges have different kind of sentencing guidelines?
I don't want to be in a position where we accept extreme, unnecessarily long sentences. So I don't think you do, or most people do. That's not the social contract I want to participate in. But I think judges, having been involved in lots of sentencings, both as a prosecutor and as a defense lawyer, there's a spectrum of judges. Some judges would be considered, if you're a prosecutor, more lenient, and if you're a defense lawyer, they'd be just more fair, right? Some judges are much more harsh if you're a defense lawyer, and some judges are, much more law and order if you're a prosecutor. There's definitely a spectrum there, and it's on some level unfortunate that a lot of what's going to happen to any defendant depends on that very initial roll of the dice, or the parlance in the legal term is like what happens on the wheel. These judges are on, like, it used to be probably a little wheel you'd spin and then you get a judge. Now it's just all done sort of electronically. But it's unfortunate that so much of justice depends on the judge you get. Thankfully, we have some very good judges who are very fair and compassionate and kind and thoughtful in their sentencing. Not every judge, necessarily approaches sentencing the same way.
I didn't know that there was so much randomness. So there's a moment there where you're waiting to see what judge you get, and then your heart sinks as you find out if you're the defense attorney.
Yeah, I remember this. This was when I was a prosecutor, and I remember sitting there in the arraignment court, and the defense lawyer on another case turned over and said, "You'll be fine as long as you don't get this judge. Don't worry, you'll never get this judge. It's a 1 in 30 chance or whatever." Boom, they announced the judge. It's that judge. I mean, everyone, you just saw the defense lawyer just put his hand in his head, and the defendant just put his head down, and it was just, I'm laughing now in the sense that it's sort of funny that the lawyer sort of overpromised it, but it was just unfortunate that so much depends on, who you draw. But I think it's hard to design a system that's not like that, or at least it's hard to design a system, where everyone would agree on what judge you get, right? Because everyone's going to have a different conception of justice.
So speaking of arbitrariness in the criminal justice system, you had a really interesting case that I had followed even prior to this being a case, which was the Marcus Hutchins case, who is a InfoSec, really well-known InfoSec personality who went by the handle of Malware Tech Blog, I think, on Twitter. And I remember, he was one of the guys that helped mitigate the WannaCry hack. And then I believe it was a few months later, he went to a conference in Vegas and got picked up by, I guess, the FBI.
Yes.
And eventually he was stuck in this kind of limbo in the US for a long time because he was British, and eventually pled guilty to having been involved in some selling black hat software on Alphabet, right?
The last part is a little different, but he did plead guilty to some criminal conduct he committed when he was a few years younger. Marcus is a remarkable person. I did that case pro bono. He really did save the world that day at WannaCry, which during the pandemic, it doesn't feel like it could get any worse. But that day, if you remember back a few years ago, was a day when every hospital in England was shutting down.
Yeah.
Worldwide. Institutions, hospitals were shutting down because of this virus. And Marcus, by sort of his genius and being in the right place at the right time, which is, shouldn't take away from it, was able to stop that and really save the world that day from what would have been in a really epic meltdown, and probably inflicted incredible harm if he hadn't stopped it right away.
So that was such an interesting case because there was definitely an element of the judge mitigating the sentence because he'd used his skills for something so profoundly good after the fact. But I guess the reason I brought it up is because it seems like, was there a suspicion that he was maybe targeted by prosecutors because he became such a high profile individual?
I think, for better or worse, a lot of times if you are well known, you may be more likely to be prosecuted. Now, the Department of Justice or prosecutors might say, well, that's because if we prosecute you, it shows that no one can get away with this, right? It also gets more coverage, so it has a greater deterrent effect. The other way to look at that would be, well, you're being prosecuted, so the prosecutor can make a name for him or herself, because it will get a lot of media attention. I think, I don't know what happened behind the scenes there. I think the judge, we had a very good judge there at sentencing who saw how Marcus really wasn't the person who committed these crimes years before, how he was a radically changed person who had done an incredible amount of good and should be given credit for that. And I think a good judge looks at the whole person and tries to sentence based on a lot of factors, not just the crime that person has pleaded guilty to or was convicted of. And that's what that judge did. And it was remarkable sentencing because the judge actually suggested that Marcus seek a pardon. There's a lot of rules for that, and you have to wait 5 years, et cetera. But I mean, I probably never have a sentence like that again, where a judge suggests that. And I think that judge did a very good job of looking at the whole person and what had really happened there. And frankly, he adopted all the arguments, or a lot of the arguments we made in our sentencing position.
So sometimes the judges, sometimes they really do make a holistic determination.
Yeah, and I mean, the prosecutors under that plea agreement, they made no recommendation, right? They were saying one sentence or the other. And of course, we came out and said he should have no prison time and should just go home a free person that day. And that's what happened. Essentially, he was put on supervised release for a year.
So that wasn't your only, you've done some other high profile pro bono cases, right?
Yes, I try to. I mean, fortunate that I can help people out who need helping out. That's probably not the most eloquent way to put it, but I've been, really fortunate that, people reach out to me who need help. And right now I'm helping out the woman who was accused of hacking into Capital One last summer or last fall. That's when she got charged last fall. So that was, allegedly one of the largest data breaches, cyber crimes in the history of the country. One thing that she or through her friends have reached out to me to help her. I'm participating in that case pro bono. And what a number of things helped attract me to that case and to Paige was that she's transgender. And I think our justice system is really just starting to understand that people who are transgender need to be treated with more respect and kindness and care. And also, there's a lot of interesting legal issues with that case. The CFA, the Computer Fraud and Abuse Act, is very broadly drawn. I would argue overly broad. And I think there's a lot of very interesting defenses that we can raise in that case. And we plan to vigorously contest the government's charges there.
And when you take a pro bono case, do you see something in the press for a defendant you think could use your help specifically, or is it typically a referral?
That one, they just reached out to me. I mean, I was aware of the case as it was all over the media last summer and fall, but I just got a reach out. So, to your point earlier in this interview, I've been fortunate and gotten some attention for some very good results I've gotten. And now, people contact me a lot of times and want my help. So that's how I got to that case. A number of her friends had, I think, even seen the result in Marcus's case and were aware of me. So, it's nice to help people when they can't help themselves. It's one of the reasons I became a lawyer. Is there are a lot of people who get enmeshed in the legal system for the first time, and it's really a very scary, trying, stressful, difficult process. And it's nice to help guide people through that process, hopefully get the right result for them, and be there to comfort them and provide them with the voice that they can't use, right? Because you speak through your lawyer once you've been charged.
Well, I sincerely hope I never have to call you for your assistance, but it's good to know that you're there.
Yeah, I mean, I would say just, I don't only do criminal and regulatory defense. I do a lot of other things, and I don't just do Bitcoin too, but I handle a lot of civil cases right now, representing Kraken and Jesse Powell in the first civil antitrust case out of the Southern District of Florida. I've handled a number of civil disputes, like I represented Charlie Shrem against the Winklevoss twins. And so I do a lot of things, but I think in all those cases, I feel like I'm, really helping people. And I think that's it's one of the nice parts about my job is that you can really help people in a tough spot. Not that I want you to be in a tough spot, Nick. So I don't plan
on
being. The point is, I hope you don't need to call me.
Yeah, I would like not to have to ever need your assistance. So where can people follow your work? You're on Twitter, I think, right?
Yeah, I mean, I became really engaged in Twitter because that's where a lot of the tech community is, Bitcoin, but also InfoSec and a lot of the tech community is there. And I really enjoy Twitter and find it very valuable to stay up on top of events. So I'm on Twitter a lot. I would say that's the number one place that people want to follow me and see what I'm working on or doing. Right now, it's a lot of, coronavirus stuff is happening in this world. And I will say Twitter, frankly, was very helpful for me in terms of seeing that coming before a lot of other people saw it coming. There were certain people on Twitter, Balaji, Selkis, who were really beating the drum on the coronavirus long before a lot of other people were, and they merely made me stand up and pay attention. So I think Twitter can be a very valuable resource for people.
Yeah, same for me as well. I mean, Balaji was so early to sound the alarm. Got so much criticism about it too, but it's sad, but he was completely vindicated.
Yeah, I mean, I think, look, people criticize me, they criticize my clients. I think if you feel like you're doing the right thing, you just need to brave the criticism, right? I mean, you can't worry about your critics, otherwise you'd be paralyzed. So I think I'm glad he doesn't care about them, or at least doesn't let them stop him from doing what he wants to do.
Well, thank you so much for appearing on the show.
Nick, I've had a great time. Thank you for inviting me. It's been a real privilege to talk to you and tell some stories.
My pleasure.